All right, welcome to another weekly edition of Taxes and Retirement Live. Who wants to talk about estate planning? I know I do. Before we do, let me start with some dad jokes, give people time to trickle in and hopefully refresh the feed on the group and get the live stream up. So first, for your dad joke pleasure this week, I got a new pair of gloves today, but they're both lefts, which on the one hand is great, but on the other hand, it's just not right. Right, left, not the same, won't fit. Short and sweet, this one. I'm done being a people pleaser, if everyone's okay with that. Ironic. And my favorite of the night, my girlfriend is fed up with my constant wordplay jokes, so I asked her, how can I stop my addiction? Whatever means necessary, she replied. No, it doesn't, I said. Because whatever does not mean necessary, get it? I love these play on word jokes. As I like to say, so bad they're good. Hopefully you agree. Quick disclaimer for the week, and this video is only general explanations and education. It's not specific tax, legal, or investment advice. Before considering acting on anything you see or hear here, first consult with your tax, legal, or investment advisor. Common sense, but I feel the need to have to say that. Excellent. So estate planning. Hopefully, you all get a lot out of this. Estate planning, I think a lot of people think it's just a will, like a last will and testament, which is what happens to your stuff after you die, basically. That is one part of it, and it is a very important part. But there's a lot more to it. It's not just a will. It's lots of things. And estate planning isn't just after you're dead. It's also can do many important things while you're still alive, like incapacitation. You have a medical condition that prevents you from acting on behalf of yourself or caring for your children or other dependents or loved ones. I don't know, you're on some remote exotic vacation trip and get lost, or people can't reach you and some important decision needs to be made. You can also, estate planning also would cover what happens in that scenario and who's able to speak or act on your behalf if necessary. It's also about wealth transfer, upon your death, admittedly, but what's the best and most efficient way to transfer whatever wealth or other assets you have to whoever you want to leave them to, and do it in the most tax efficient way possible. It could also be things like Medicaid, shielding your assets from Medicaid. So if you are seriously ill and have long-term care needs and you don't have insurance, or insurance isn't enough or whatever, and you end up needing to be in a long-term care facility for a long time, you could potentially deplete your assets. And then once you deplete your assets, then Medicaid kicks in, but you basically need to, I forget the exact levels, and it all depends a little state by state, I think, but you kind of need to spend on everything except your house, I believe, and some nominal amount of cash you can keep. But otherwise, you basically have to spend on everything. So part of estate planning is, if you choose to, you could start getting some of your assets out of your name ahead of time. It needs to be at least 5 years before the medical event happens, for to shield the stuff from getting eventually clawed or have to be spent down by Medicaid. But that's part of estate planning. Planning ahead to sort of get some things out of your name. If and when you need long-term care, you won't have to deplete those assets because they won't be yours anymore. There's a handful of ways to do that. And also just generally protecting assets from creditors, whether it's bankruptcy or other sort of slip and fall lawsuits or something like that. Estate planning could help protect your stuff from claims of creditors and other folks like that. So, other disclaimer about estate planning, I'm not an attorney, I'm not an estate planning lawyer, nor do I play one on Facebook live streams. So what I'm saying now, is to the best of my abilities and knowledge and my understanding of how all this stuff works. Also, a lot of it will depend state by state. A lot of these agreements and legal documents we're going to be discussing, the laws that govern them can and will be dependent on the state you live in. Now, a lot of times the states have sort of comparable approaches in governing laws to these things, but they can potentially be different depending on the state you live in. All right, so let's start with the probate process. I just want to explain what that is. There are some legal terms here we can't avoid, so I'll try to keep them as minimal as possible and explain what they are. So probate is just simply the legal process of what happens after you die. It's a legal process of sort of taking what you have, paying off what you owe, giving what's left to whoever your beneficiaries are. And that's all governed by or overseen by the state in which you live. Specifically, it's going to be the county in which you reside or own property. I think that's almost always, if not exclusively the case, the county you live in or own property in. Now, what I don't know the answer to is if you have multiple residences or properties in different states. I think the gist is it's supposed to be wherever you're domiciled. Now, I guess that could be defined in different ways depending on where you live and whatever, but just practically assume it's wherever your primary residence is. That's the state and the county in which your probate process will be overseen. So again, probate after you die, it's the divvying up of your stuff to your creditors, paying your final expenses, and giving what's left to your heirs and beneficiaries. There's a handful of steps, and this could all vary state by state, but at a high level, once you pass, if you have a will, and I'll touch on what a will is in a little more detail, but if you have a will that names an executor is a person who administers your estate process after you're dead and oversees this probate process. The executor will take the will and go down to the county court and hand it into them for the court to approve it. The court can deny it, but let's assume in most cases the court will approve your will. At that point, the executor is off and running with the process. If you don't have a will, a relative or someone has to go down to the court and have the court appoint a personal representative, which is functionally the executor, but it's just kind of the name of the role when you don't have a will, and the court then appoints who's going to oversee the probate process for you. Okay. So that's the first step. You bring your will down to the court, and the court stamps it to say, yes, go ahead, do your thing. After that, the executor then will give notice to all the heirs and beneficiaries as detailed in the will to give them the chance to object. Now, assume things function well and your named beneficiaries aren't up in arms about it. Like let's say you have 3 kids and you give 90% to one kid and you split the other 10% to the other 2 kids. Well, maybe the other 2 kids aren't cool with that and they can object the will. Then it could get messy and dragged out and the courts get involved and have to decide, does this will stand or will I override it or whatever. But let's just assume you go out, the executor tells all the heirs, tells the beneficiaries, hey, this person's dead, we're going through the probate process. Let's assume all those people are cool with it. Fine, move on. Next step is the executor has to notify any potential creditors, people who are owed money from the decedent. Decedent is just legal speak for person who died. So the executor goes and tells the world, often this is done through a newspaper ad, and that's considered notice enough because the executor may not know all the people who are owed money from the decedent. So just by blasting it out to the world through a public venue like a newspaper, that's usually good enough. After that, assume the creditors that there are come and ask for their monies, and the executor has to confirm yes, these are legitimate claims. At which point they actually pay out the monies owed to the creditor or creditors. In addition to paying out debts, you also pay the final expenses, funeral, cremation, burial, whatever. Taxes, any taxes owed by the estate and things like that. Once all those are paid, then whatever's left, that gets divvied out to the beneficiaries as designated in the will. Or if there's not a will, that's where the court decides, okay, who's going to get what, whether it's, spouses usually get everything, depending on the state more so than others. Spouses get everything. But it could also be children, aunts, uncles, cousins, friends, whatever. It's in the court's hands. So if you want to have some say over what happens to your stuff after you're gone, you definitely want a will, at a minimum, maybe a trust, which we'll touch on later. Don't just wing it. If you wing it, you have no control over what happens to your stuff. Now, family members can come and try to make a case. This is what he or she would have wanted, but it's ultimately up to the judge and the court overseeing it to decide what happens to your things and who gets what. That's what happens if you don't have a will. Not having a will is called dying intestate. Intestate. It's all one word. That just simply means you don't have a will and you die. It's called intestacy, which is, as I said before, the court decides who gets what and when and in what proportions. So once all your stuff is handed out, then the final step is for the executor to close out your estate. There's the official filing that yes, this estate's done, the decedent's belongings have been divvied out, creditors haven't paid, whatever. There's also final tax return. The estate often has to file a tax return for itself. In addition to the decedent filing his or her own last final tax return, the estate of the decedent, the stuff the decedent had becomes his or her estate upon death. That estate often needs to file its own tax return, or someone files it on behalf of the estate. So that's the probate process. Again, probate just means the legal process of your stuff getting paid out accordingly to whoever's owed, and then what's left getting sent to your heirs. Okay, let me stop and check some comments here. So Cody was kind enough to summarize some of the comments. Tony Morrow, what kind of trust do I need to set up so it cannot be taken from a nursing home? Good question, Tony. Let me hold that till the end. I will be touching on that at the end. Teaser, it's called the Irrevocable Trust, but I'll explain what that means. Scott Smith, pros and cons of naming your trust as a secondary beneficiary for IRA accounts. Ooh, yeah, that's a frequent topic of discussion in the group, Scott. Let me hold that to the end when I talk about trusts as well, but great question. Canon says homesteading. Not sure what that means. Isn't the idea of estate planning is to avoid probate? Another question from Canon. Yes, that is one of the goals of estate planning, is to ideally keep as much as possible out of the probate process, out of the court process. And probate is all public record, by the way. Whatever assets of yours transfer upon your death through the probate process is public record. Now, honestly, I haven't gone and tried to do this myself. I don't know how you go and find. I guess you just call up the court and walk in there and say, hey, I'm looking for someone's will and probate records or whatever. But in theory, anything that passes through probate is public record, and anybody can find out about it. So, like, if you don't want people to know that you had $2 million that transferred to your Aunt Sally or something, don't have that go through probate if you can control it not going through probate. Otherwise, it will be public record. And a trust keeps stuff out of probate. I'll touch on that again at the end when I talk about trust. But having things go to a trust, what happens in a trust and what comes out of a trust of beneficiaries is not public record. That's private. The only people who know are the attorney who drafted it for you, and the trustee who oversees the running of the trust. But I'll touch on that more at the end. Good question, Kenan. Kathy, what would be a good resource to find someone to write a plan? I'm in Ohio, and what type of fee should I expect to pay? No kids or spouse, and simple assets, house, and investments. Kathy, I don't know if you're asking just about an estate plan. That's not really its own thing. I mean, if you want estate documents, an estate planning attorney would do that. You can just Google estate planning attorney or in your area. Otherwise, that will be part of, or should be part of, a good comprehensive financial plan where any good financial advisor will help you work through those things and plan for not just what to do with your stuff while you're alive, but how to transition and work with you to figure out where you want it to go and what's the best way to do that upon your passing. As far as a fee, that's all over the place. Depends who you work with. A lawyer around me in central New Jersey, not far outside New York City, so we're not a cheap area by any means, to have a lawyer draft up a basic set of documents, and I'll discuss what there's 4 basic documents. It's like $3,000 roughly, $2,000 to $3,000 depending where you go, maybe a little more, potentially a little less, but it's a few $1,000s just to get the documents in place. Now, they don't really help you plan per se. That's just the drafting of the documents based on whatever your wishes are. If you need to work with someone to figure out, well, what should my wishes be? And I don't know the best way to do this or do that. That'll most likely be a financial planner who's well versed in estate planning as part of what they do. In that case, to just have some one-time plan written up, it's easily a few $1,000s. If you want ongoing advice, it's thousands of dollars a year potentially. So not a great answer, Kathy, but it really all depends what exactly you're looking for. How involved and how extensive you want the work to be, and how much lawyers need to be involved or not. David Foltz, when the spouse dies, that is the last year you would be able to use married deduction on a tax return. Yes, that's correct, David. So when you're married, you can file as married as a joint taxpayer. If you die in the year of the death, whether you die January 1st or December 31st, the surviving spouse can file as married that one last year. Years after that, it needs to be single, unless he or she gets remarried, in which case it's married again. You can file married again. There are some exceptions. There's something called qualified widow/widower and something called head of household, David. Those basically only apply if you have kids or other dependents. The surviving spouse has children or other dependents on their tax return. Then maybe you can stretch it out. I think it's like 3 years perhaps. But if you, assuming you don't have kids or dependents, yes, the year of death is the last year that the surviving spouse can file as married. Each subsequent year will be single. Alan Thomas, what if all I have without named beneficiaries and TOD is a bit of inexpensive furniture? Do I still need a will? Good question, Alan Thomas. For everyone else, POD and TOD, and I'm going to touch on that, it stands for payable upon death or transfer upon death. Those are ways you can leave things like bank accounts and brokerage accounts to other folks upon your passing. The titling of that account means pay it on death or transfer on death to so-and-so. So that's a way to avoid having to go through a will. So yes, Alan, if you have like literally nothing else that would or could pass through a will other than a few $1,000 of old furniture, no, you may not really need one. Some states, like I'm in New Jersey, they have an expedited probate process where if your total assets are under $20,000, I think it is, there's like a simplified short form probate that's supposed to be quick and painless. I don't have firsthand experience with it, but it's supposed to really expedite the whole process. I've heard horror stories of how painful and dragged out probate can be. I've also heard in some cases it's not that bad. For what it's worth, in New Jersey at least, when the executor notifies the creditors that the decedent is dead, the creditors have 9 months from the date of death to put in their claim to get paid from the estate. So the probate process in New Jersey could commonly be at least 9 months. Now, the executor can close it up whenever everything's wrapped up, but the risk is that what if the executor closes the estate 4 months after death, and there's still 5 months after that a creditor can come in and stake a claim on the estate. So if a creditor comes in, some point in that 5-block period, well, now the executor has a mess on his or her hands. So if an executor wants to be thorough and conservative and make sure there's no outstanding claims that can still come in after the fact, an executor should leave the probate process open for 9 months, at least in New Jersey. Again, this could all be drastically different state by state, so I'm only talking about New Jersey right now. But yeah, good point, good question, Alan. Okay, so Cody's just sharing some insight how to actually search for this stuff. Ken adding some money for a trust. Yes, so Ken says, I asked several estate planning attorneys around here, they want $3,000 for a trust. Is that the reasonable rate? It doesn't sound unreasonable. It all depends where you live and how experienced the attorneys are. If you go to a new, eager for work attorney, he or she will probably charge you less than if you went to a 40-year-old established practice where the big shots there charge $600 to $800 an hour. $3,000 isn't crazy, but most trusts, depending how complicated the trust is. Now, I'm only going to touch on trusts at the end because there's dozens of trusts, if not more, and they can get really customized and really complicated. So depending what trust you're talking about, Ken, if it's just a basic, what's called revocable trust that I'll discuss later, $3,000 is probably not crazy, especially if you're in a relatively high cost area of the country. All right, let me move on. Questions keep flowing in here. So I'll stop with Ken's question about $3,000 for a trust for now. I will try to come back to as much as I can, but let me just march through with the rest of the stuff here. All right, so as for the 4 legal documents that, in my opinion, everyone should have, if you ask lawyers, could be slightly different. Some people throw a trust in here as like a 5th agreement. I view that as something separate, and I'll talk about trust at the end. So there's really 4 estate planning documents that in my mind I view as like the 4 you should have. Trust could be a separate thing. Trust isn't just a document. A trust is its own living, breathing entity, if you will. So that's why I don't consider it in the same vein as these 4 things. Just look at my screen here. So here's the 4 documents you should have. 1 is the last will and testament, otherwise known as a will, and I'll step through what each of these are. 2 is a financial/legal power of attorney. 3 is a medical power of attorney, and 4 is a living will. So first, last will and testament. This is just the will, which I assume most of you know, at least minimally, what that is. That does a few things. If you have kids or dependents, it lists who you want to be the guardian of those, or what's the other word? Conservator, perhaps. I'm drawing a blank. Basically, the person who's legally responsible for raising and overseeing your child or dependent. So a will name that person or persons. A will also says what you want to happen to your stuff. Whatever's left. You want this much to go here, this much to go here, whatever. Will also names who you want to be the executor or executrix, I think is the female equivalent of executor. That's, like I said, the person who will oversee the process of probate for you. And it's potentially a lot of work, especially if you have a complicated and messy financial life or probate process. So think closely, not closely, really think about who you name as your executor, executrix, because you want someone who's smart, responsible, has a good head on their shoulders and can understand and have the wherewithal to walk through this process and the potential headaches of it. So anyway, so that's what your will does. A will can also say what you want to happen, to your remains, or final. Do you want a burial? Do you want to be cremated? Do you want to be dropped off at sea somewhere, or whatever? So that's a will. I'll leave it at that for now. The next one is the power of attorney. And this is so will is what happens after you die, right? We all sort of know that. That's what we all think about, what we all think estate planning is. This is while you're alive. These other ones are while you're alive. So power of attorney is just simply, if for whatever reason you're not able or around or don't have the mental capacity to make legal or financial decisions on your own, the power of attorney will grant that power to someone else. Now there's two, and it could be financial and or legal. So like opening or closing bank accounts, or doing financial transactions for you, or making legal decisions about transferring ownership on something, or having to sign off some contract on your behalf. That would be like a legal power that you would delegate to someone. There's a few terms to keep in mind and a few differences. Just want to make sure you can see this. Yes, okay. With power of attorney, they could be limited or general. Limited means you only give someone the power to do certain things. Like you can only you can only take money out of a bank account. You can't sign legal contracts for me. You can't enter contracts. You can't terminate contracts, things like that. So that could be limited. General basically means you can kind of do whatever. You have the full function to act in whatever capacity necessary to act or to sign off or to make decisions as if you're me. And then it could be durable or springing. Durable means it's in place now, and it's functionally always in place. Springing means that power you're granting to someone only springs into action, springs into place upon some event. And that event could be like you have a stroke and you're incapacitated and can't talk and can't make decisions. Do you want durable or springing? That's kind of up to you. So durable is in effect basically from the moment that thing is signed. Even if you're fully of sound mind and body, that person who has power of attorney, a durable power of attorney, can also sign stuff or take money out of your accounts or whatever. So think about why you're doing it and what your intentions are before you give someone durable. Springing, like I said, only once you stop having the ability to make decisions for yourself, that's when the other person's powers or abilities spring into being. So those are key terms to understand. Next is medical power of attorney. Where are we at? So whereas this one is just financial and legal matters, medical is about medical decisions. So if you're, again, not, I want to say not willing or able, but not able to make medical decisions on your behalf about whether or not you want certain treatments or whatever. Do you want this IV or that IV? I don't know. Someone who can make decisions for you. Now that's different than a living will, which is also medically related. But a living will is specifically about end-of-life decisions. So you're in a vegetative, permanent vegetative state. Do you want life support, or do you want the plug, the proverbial plug pulled? I guess it's not proverbial. I guess it's literal. But anyway, that's a living will. So that's different from medical power of attorney. Medical power of attorney is not end-of-life decision-making. It's just like, hey, you got in a bad car accident. You're in a temporary coma. You need someone to sign off on this treatment. That's medical power of attorney. Living will is, there's, multiple doctors have said there's no chance you're coming back from this. You're going to be on a feeding tube the rest of your life. Do you want that support pulled? That's a living will. You grant someone the authority to make that decision for you when you can. And don't get too hung up on the names of these four things. They go by lots of different things. Depending what state you're in or what lawyer you're working with, you may see these all referred to as different names. Like this is also an advanced medical directive. I've also seen this referred to as an advanced medical directive. So don't get hung up on the names. Worry more about the function. The functions I explained for each of these four. That's the important things. Don't get yourself in a tizzy about the names being different than what I mentioned that they were. All right, let me stop and take some more questions here. So going back to Ken. Ken said, I plan on doing a will with will maker software. That said, my wife and I will both need to have separate wills. Yes, I've always seen them done separately, Ken. I don't know if you can't do it as a married couple. My own will is separate with my wife, and clients as well always are separate. I don't know what pros there would be, if any, to doing it as a married couple, but I would assume you probably should do it separately. Pearl asks where to store original documents. Yeah, good question, Pearl. So often the lawyer who does these documents for you will keep physical copies somewhere in safekeeping. They should all have like a vault or a safe or somewhere safe from fire and theft and whatever. You'll get a official hard copy as well that you should keep somewhere safe, whether it's a bank vault or a fireproof safe in your house or whatever. I would also recommend scanning them, getting things saved electronically. In addition to the hard copy, save them. And now wherever you choose to save them, that's up to you. Now this brings in, I'm glad you brought this up, Pearl. This brings up an interesting question about digital assets. Like everyone knows, yeah, I have a house I have to transfer upon my death, or, I have an IRA or cash or whatever. But digital assets are increasingly large and increasingly important. Like photos, all your photos. Who has access to them? Who's going to get them? Who knows the passwords of where those photos are saved and how to get into them? Are they in a cloud somewhere? Are they on a thumb drive? Are they on disks? So going back to your point, Pearl, about where to store originals, you should also keep it electronically. Where's it going to be? Your executor needs to know where your will is, because without it, he or she can't go bring it to the court upon your death. So whether the executor has a paper copy or knows where the hard copy is and has access to it, or has a thumb drive or some other access to it electronically, or a combination of all these things, it's kind of up to you, Pearl, where you choose to keep it. Just make sure your executor or executrix knows where it is and knows how to get at it if and when they need to, take it to the court after you're unfortunately no longer here. Tara, does naming a POD recipient on bank accounts make a difference if there is no will? Yes, Tara, it does. So POD, I'm getting a little ahead of my content here, but POD stands for payable on death. It's a way that if you open up a checking account or a brokerage account or whatever, and you want it to go to your brother Joe upon your passing, you can open up the account and title it. Titling just means like what you label it or how you structure the ownership of it. It'll say, Andrew Panko checking account, POD Joe Smith. And that means if and when Andrew Panko dies, the bank knows that account is now payable on my death to Joe Smith. So that is a way to circumvent a will, Tara. So if you don't have a will, POD definitely helps. Even if you have a will, POD helps expedite the process, because now there's no ambiguity about what you wanted to happen to this particular account. This account's going, it's payable to Joe Smith in this example. If you did not have a will and you did not name a POD, payable on death, on your account, Tara, it's up to the court to decide who gets it. It's now the court's discretion where that account goes, whereas if you named a POD, you owned and controlled who gets it after your passing. Or if you didn't do POD and you had a will, that will say where that account goes upon your passing. So you definitely want one of the two, POD naming and or a will, to make sure that account ends up in the hands of whoever you want it to go to upon your death, Tara. And we should ask, how frequently do you update the document? I would imagine things change as time progresses. Yes, definitely, and we should. Good question. I need to update mine, to be honest. It's been a while. If there's any substantial changes, like let's say the people you named as guardians for your kids, you no longer want to name them, that obviously means you would need to change your document. Now, some of these amendments can be really simple and easy. I think it's called a codicil, or codicil is the official legal term. That just means like a simple amendment to your existing will or document. So you can just simply swap out the name of the old guardian for the new guardian. If you want to, some of your beneficiaries change, you had a falling out with your brothers or your aunts or your cousins or whatever, you can change them as well. Now, I don't have specific examples, but I've had legal colleagues of mine say there is like base legal language in these documents that gets outdated as rules and laws and approaches towards estate planning change, that there is like standard, what they call boilerplate, that's standard legal language. in estate planning that does get outdated over time. So if your will is more than 5, definitely 10 years old, I think it's time to revamp it, is my guess. And I don't work for a lawyer, so I have no incentive to tell you, yes, go do a new will, but that's the advice I was given, and it makes sense. 5 years, maybe that's too short, I don't know. 10 years feels like it's a long enough time that, yeah, it's probably time to update your stuff. Okay. So Lori, given $5,500 outside of Boston, doesn't surprise me. That's a high cost area. Just looking at other questions here. Carol asks, is there a certain net worth where it makes sense to have a trust? Good question, but not a simple answer, Carol. A trust is more about protection and control of your assets, and to some extent ease of estate administration, or actually circumvention of estate administration, because whatever goes into a trust and comes out of a trust is outside of the probate process. Whether you have $500,000 or $5 million, I don't personally think it matters. What matters is, do you want there to be anonymity to what you're passing, meaning you don't want your probate process to be public record? In that case, yes, a trust. There's not really tax savings to it. If the people you're leaving your assets to have issues, like they're spendthrifts, they'll blow it. You're afraid they'll blow it, or they have substance abuse problems, or other special needs, then trusts come into play, where you can control, from the grave, basically, because you can structure your trust now to say what you want to happen to your stuff and when, after you're gone. Then a trust makes sense. But if you're just simply leaving it to a friend or to a cousin or to whatever, and you're not worried about what they're going to do with it, and you're not concerned about the anonymity or lack of anonymity by your stuff going through probate, I don't personally think it matters. It'll make it marginally easier for the executor to deal with your estate. But if you don't have like a crazy complicated financial life, I don't think it's necessary, in my opinion, Carol. Okay. And good about trust. So I mentioned, again, if protection and control, like if your heir is going to be a spendthrift or substance abuse or special needs is a big one. And I'm not an expert in special needs planning, so I'm getting ahead of my skis here, but that's one really strong example of, if you're leaving assets to a child who's always going to need assistance throughout life, or a grandchild or whatever, maybe they're getting assistance from the state, from the government, and that'll be based on their assets or lack thereof, perhaps. So if you have $1 million and you leave it to a special needs person, well, guess what? The state or whoever's giving their care may suck all $1 million of that out, and then it's gone. Or they won't qualify for care because now all of a sudden they have $1 million. So by putting it in a trust that's sort of blocked off and not in the name of the special needs person, him or herself, whatever caregiver or state or assistance or subsidy they're getting won't be able to see these trust assets, because the assets are assets of the trust, not of the person. But so that you can structure so the trust dribbles out a little bit of money every now and again to the person, but not so much that it knocks them out of eligibility for getting whatever special need assistance or care they're getting. That's a little more, again, beyond my realm. I'm not sharp enough in special needs planning to be an expert in that, but that's one of my understandings of where a trust makes a lot of sense, and when you're leaving money to a special needs person. Tony, blended family. Can we have my son and husband's daughter as co-executors? I believe so. That may depend on state. I don't know if some states require there to only be one executor. In theory, I assume you can, but check with your state. It could be trouble. Yeah, I was just about to say. So Anwisha said this could be trouble, because now you got two people having to make decisions, and if they have 50-50 power, what if you get to a stalemate? So maybe, I don't want to say go and do 3 people, because that's now asking for even more trouble, but I think in theory it could happen, but it may end up potentially backfiring if there's a stalemate along the way. All right. Tara, yeah, so Tara asks, are banks obligated to acknowledge a POA? Interesting question. From personal experience, apparently no, they're not. I have a durable, full durable, meaning I have the power now, power of attorney with a family member, and we went into this person's bank to give them a copy of this legal power of attorney and said, here you go, put it on your records. Like, nope, we can't accept this. I was like, what do you mean? They have their own form they want and need filled out. I don't know if that's a legit practice or them just doing CYA and being overly cautious. They want to make sure that it's their form and their language that everyone's signing, not some other potentially generic template that some other lawyer made. So in that case, thankfully, the person was still here and was with me when we were at the bank. It wasn't like I had to go in after the fact and have this fight with the bank. But the bank did make both of us sign their own form of power of attorney. They did not accept the professionally drafted power of attorney we had had done by a very experienced estate planning attorney, Tara. So something to keep in mind. All right, let me pause it there and go on some more. Okay. All right, so that's sort of the probate process. The will says what you want to happen to your stuff that flows through probate, and then those other documents are kind of what happens while you're still alive. Power of attorney, medical power of attorney, living will, which is end of stage medical decision making. Not all assets pass through probate. There are some assets that explicitly stay outside of probate and should not be pulled into a will or the probate process because it kind of defeats the purpose. The big ones are life insurance and annuities that have a life insurance death benefit component. Those things pass by pass by contract. And then retirement accounts, IRAs, 401ks, Roth IRAs, pension if you have one, any sort of those qualified retirement-based accounts, those all pass by beneficiary forms. You don't need to, and probably shouldn't ever, maybe, put them in wills. So let's start with life insurance. When you buy life insurance, you say who you want to get the death benefit. When you die, I want the proceeds to go to my wife in my case. If my wife predeceases me or we both go at the same time, it goes to my kids, 50-50. That contract, that is in effect the will. That's saying once you die, here's where this money goes, boom. Notice that there is no will in it. It's just simply this contract says where the money goes. Completely irrelevant to whether or not you have a will at all. This insurance proceeds goes to whoever's on this form. Done. No need to overcomplicate it. Don't run insurance through your will or anything like that because you don't have to. Also, just like you should update your will every now and again, 5 years, 10 years, whatever, do the same with your insurance beneficiaries. I've heard stories on podcasts and whatever where people have gotten divorced and never updated their life insurance, and guess what? 5 years later they get remarried and die. Well, the ex-wife is getting the insurance because the policy was never changed. So definitely something to keep in mind. Because that stays out of your will. So if you change your will, great, you change whatever passes through there. You may change its beneficiaries, but your life insurance has its own beneficiaries and your retirement accounts have their own. So let's talk about that next. Again, IRAs, Roth IRAs, 401ks, 403bs, traditional defined benefit pensions. They all pass by contract as well, specifically by beneficiary form. When you open up an IRA at a brokerage account, you will see in the account application a beneficiary section. Fill that out. That takes place of the will. When you die, the bank doesn't, the broker doesn't need to look at your will at all. It doesn't matter. Whatever's on its beneficiary form, that's where the money goes. To the extent your will says something different, I don't think that matters. The will's basically, it's cut out. The beneficiary form is what matters. So make sure your beneficiaries are filled out properly on your accounts, again, your retirement accounts. And don't forget to update them, especially if you get divorced and move on, to get remarried. Make sure you change your beneficiary forms. And you can change this stuff anytime, whether it's life insurance or these retirement accounts. It's pretty quick and easy to do. Usually inside of a day or two. It's generally just a form you fill out. Often now it's online, or submit it through DocuSign or something like that. But stay on top of making sure your wills get updated and your beneficiary forms like life insurance and retirement assets. So those are assets that pass outside of probate, life insurance, and retirement accounts. There are other assets that are probate assets, but there's ways you can circumvent it, and we've already got ahead of ourselves. That's like the POD and TOD. So again, POD means payable on death. TOD means transfer on death. And you can do things like houses. Houses are probate assets. Non-retirement financial accounts, checking accounts, savings accounts, regular brokerage accounts, certificates of deposits. Excuse me. Those are all probate assets that would normally go through probate, i.e. your will, but you can skip that by naming a POD or a TOD recipient on it. That means when you die, pay this account to whoever or transfer this account to whoever. That's a quick and efficient way to speed up and minimize the stuff that flows through probate in your will. All right, let me, what do I got left here? So that's called titling. Oh, there's more to it than that, sorry. So in addition to POD or TOD, you can also own assets in a certain way that automatically transfers your ownership or your interest to someone else upon your death. Most common is like married folks. You own a house, you probably own the house together. When you record the deed, you likely own it as joint tenants with rights of survivorship, which means the two of you are tenants, meaning owners, not tenants as in you rent it. Tenants is a legal word for like you own, you have an ownership stake. Joint tenants with the rights of survivorship means when one person dies, the other person automatically gets the decedent's portion and becomes the owner of it. There's other forms like tenants by the entirety, and this all varies state by state again. So not all states allow this. I think only like half do. Tenants by the entirety is something only married people can use, and you can only do it 50-50. So you can't do like 75-25, whatever. It's sort of like joint tenants, but has to be 50-50 and has to be married people. There's also tenants in common, which is you can do for non-married people, and you can do in different portions. But that doesn't really transfer upon death. That just means like, you and two of your friends own a house. You can split it 30-30, 40 if you want, whatever. But each person can sell off their own part independent of the other. You just keep your portion. The difference with joint tenants with rights of survivorship and tenants by the entirety, you can't sell your portion without the other party consenting to it or acknowledging it and agreeing to it. So those are other ways to transfer stuff outside of probate. So again, especially for spouses, you're likely going to own a lot of your assets, or especially big assets, jointly. When you die, they automatically just end up in the hands of the other person. That helps avoid the probate process. All right, last is trust, but let me go through some of these comments here before we get to the fun world of trust. Okay, Kathy asks, in springing financial power of attorney, I'd like to do in case I get dementia, but even with dementia, there are good and bad days. How would someone decide when the spring is sprung? Yeah, that's a good one. I don't know, honestly. I would think you would really have to spell this out in the document. Like if you're concerned about good day, bad day type thing, really spell it out and say, for the avoidance of doubt, the fact that I can't talk for 5 days, but can likely talk on the 6th day, doesn't give you the power. Talk with the lawyer you're in and the state laws that you're subject to. Kathy, maybe the wording is something like it needs to be without doubt and no question that the person's mental capacity will not be returning, or something along those lines. It needs to be verified by a doctor. That can be one of the conditions in the thing. But you can structure these however you want. They're legal contracts. They're all customizable. You can, however creative you and your lawyer are who make it, you can make it say whatever you want, Kathy. So in theory, sky's the limit with how you restrict the ability to, or when the spring could be sprung. I like that term, Kathy. All right, so Cody talking about sweetheart wills. Yes, thank you. Mark saying Fidelity has a storage service that's free. Yep, there are other ones out there as well. Yeah, thank you. David says, even though you have a will, if you name beneficiary on your investment account, that takes precedence over the will if they are different. Yep, 100%. So like your IRAs, Roth IRAs, 401ks, whatever you have in your will, doesn't really matter. It's what's on the beneficiary form that matters, to David's point. Kathy asks, can payable on death go to multiple persons? I don't know. Good question. Perhaps. It maybe the bank or broker puts restrictions on it. I don't know that it's a black and white legal matter. It may just be the bank doesn't want to bother with naming 10 people as POD, Kathy. It's worth asking. Ask your bank. I would assume it's a simple answer that they should know quickly and easily. All right, what else we got? Cannon asks, how do you avoid your assets from being partitioned when passed to your children and they divorce their spouses? Yeah, that's a good one. I don't know this with certainty, and I think some of it will depend on state law, depending what state you're in. But I think it also depends if it's a community property state, of which there's 9. I don't know. I'm going to make up an answer based on my educated guess here, Ken. And again, this could all be very different depending what state you're talking about. But a trust is definitely one case where you can, again, trusts are for protection and control. You can protect and control where that money goes or doesn't go by going to the trust. You can set up a trust that says, upon my death, this money goes here. It can be used only for my, what did you say, son or child, whatever, child ABC. In no event can any of it be used directly for ABC's spouse or whatever. Trusts are all customizable as well. The sky's the limit on how creative you want to get with the limitations and structuring and whatever. But that's one way to do it. You can have it not just go, not only prevent the current spouse from getting it, but any future spouses down the road. That's definitely a possibility. If you don't use a trust, then I'm not sure. Then I think it's going to default to whatever the state laws are about things. And it could be different if it's a community property state or it's not. Just not sure, Kenan. Okay, so Cody replying to Carol about trust and estate taxes. Yes. Right. So Cody raises a good point. Estate taxes, which are basically, at least at the federal level, if you die and you die with more than I'll round up to $11.6 million worth of assets in your name, that first $11.6 million is not taxed by the federal government. Anything above that, you have to pay an estate tax on, or your state pays the estate tax on. For married couples, it's double, so it's what? It's $23.2 million, let's call it. That's unusually high, these levels. They were increased in the last few years they were roughly doubled. So it was like $5.5 million per person or $11 million per spouse. Prior to the Tax Cuts and Jobs Act, I think is what increased them. I fully expect these will go down over time. To what and when, I don't know, but I don't think they're going to stay the generous $11.6 million per person they've always been. Will they go back to $5-ish million? Hopefully. But not too long ago, it was like early 2000s, it was like $2 million or something per person, estate tax exemptions, which wasn't very much. It's fairly easy if you have life insurance, you have a house, you have some investments. It's fairly easy to end up with more than $2 million upon your death. So in that case, trusts were I'm getting into the trust thing here. Trusts were used to get the money out of your name before you died, so it wasn't your assets anymore. It was the trust assets. Hold that thought. I'll touch on that in a moment, because there are drawbacks to putting money in an irrevocable trust, because they're no longer yours once you give up them. You give them up irrevocably, and you lose all rights to them, subject to whatever the trust rules are. But hold that thought. Okay, yeah. So sorry, I see a bunch of you responded to other people's comments. Thank you for that. I'm going top down, and I don't see the full list. So like it's not until I scroll down that I see other people have already responded to others' comments. So thank you, and apologies if I'm as I answer stuff that someone else already said. Okay, Cannon says all investment accounts typically have beneficiaries, so do they stay out of the will? Not all investment accounts, retirement accounts do, Cannon. IRAs, Roth IRAs, 401ks, 403bs, pensions, those have beneficiaries. Normal, regular brokerage accounts, like taxable brokerage accounts, do not have beneficiaries. Those are probate assets. They pass through your will, or if you name a POD or TOD, they'll pass that way. But they do not have their own designated beneficiary forms to that for regular brokerage accounts, and neither do like regular bank accounts, checking and savings accounts. And Cody, yeah, good. Should have scrolled down. I see Cody replied to Kenan, so thank you, Cody. Okay. Here's one about IRAs and trusts. Let me just see if someone else answered it. All right, so Julia asked, if you name an individual beneficiary on your IRA, does it avoid going through probate? Yes, 100% does avoid it, Julia. So there's another question here about trust. Let me hold that because I'll get back to it. About naming a trust as a beneficiary. Right, so Pearl said, do IRAs with properly completed beneficiary forms belong in a trust? No. They can be in some circumstances. Now I'll get to it now because this is a good one, and it's come up a lot in the group. So, okay, actually, hold on a second. I'm about to get into my trust spiel. I'll touch on that then. Kathy asks, what happens if the financial power of attorney you specified dies after they have taken control of your assets? You would have to specify a secondary, basically. So you can do that ahead of time when you fill out your power of attorney. Say, primary is this, secondary or contingent is this, that. You can name as many people as you want, but that's a legitimate concern. Right, you should have a secondary named. Or you can just name that if that person dies, their power goes away, but then you're left with, assuming you're incapacitated, then what do you do? So then the court would basically appoint one. One of your family members or friends most likely would have to go to the court and say, hey, Kathy's power of attorney just died. There's no replacement or contingent person named. Kathy can't do this stuff on her own. She's a permanent coma or something. So the person has to go to the court and petition the court to say, hey, make me the, is it called, conservator or guardian? I'm getting the legal terms confused. But basically someone has to lobby the court to say, Kathy can't do this. No one else can since the power of attorney died. We need to make someone the new representative for her. I nominate myself or this person or that person. Then the court decides who is the right person to do that on your behalf, Kathy. So if you want to have the say, definitely have a primary and one, if not multiple, secondaries or contingent powers of attorney if you're concerned about that person dying while they have the power. Okay, Layla asked, are there trust companies that can handle the financials while alive if you have no one in the country whom you can name as an executor? Yes, there are professional trust companies who will do all this stuff gladly for a fee. Yep. So Alan asked, Fidelity calls it a beneficiary designation for brokerage account. I guess it's really POD. Yeah, probably. Yeah, good point. I don't know if it's 6 of one, half dozen of the others, or if there are... if there is any significance or difference. POD, TOD, I don't know this for a fact, I'm making this up maybe, may still be a probate asset in that it may be public record, but the transfership of it may be out of the will and dictated by the POD or TOD nominee, Alan. That's my guess. I could be wrong. If anyone else knows, please chime in. But the difference between being a true beneficiary account, like a retirement account that has a beneficiary form, I'm pretty certain that stays out of public eye. That stays out of probate. Regular brokerage account might still go through probate and that is publicly known, but the POD or TOD would determine who gets it. Layla asked, would you go back to what you just said about taxable brokerage having no beneficiary? Yes, so if you have a regular brokerage account or a regular bank account for that matter, or your house or any other probate asset, and you don't have any beneficiaries or PODs or TODs or joint tenants named or whatever, and either you don't have a will or you have a will but the will doesn't specify where these things go, then the court decides who gets what. So if you don't want to leave it up to the court, you definitely want to have a will for stuff that goes through probate, and or even have these POD, TOD namings and titlings to make it even more bulletproof, Layla. And yes, I see Cody just jumped in with some other stuff. Good, thank you, Cody. All right, so let's move on to trust. Now this is just going to scratch the surface. Again, so I'm not a lawyer, I'm not a trust expert. There's potentially infinite different types and flavors of trust. I'm just going to talk about a couple of the main ones that are most common for most people. So again, a trust is just for protection and control. Don't think about it as a way to minimize taxes. In some cases it can, especially if you do like a charitable trust where you want to give money, bundle it as a charitable donation. There's lots of creative ways to do that. It could be more work than it's worth, and unless you're truly charitably inclined, that may not be the best way to go about it. But point is, don't think about trust as ways to necessarily get rid of taxes or minimize taxes. Unless you have so much money, where, as Cody mentioned, you're going to die with more than the estate tax exemption of currently $11.6 million per person, then yes, and maybe you want to get stuff out of your name into a trust that can minimize or eliminate estate taxes. but it won't necessarily get rid of tax while you're alive. I mean, I guess it could in some cases, but trusts have a high tax rate. So I'm saying a lot of things at the same time. So let me just step back a little bit. So a trust is its own legal entity, if you will. It's not a living, breathing person, but in the eyes of the law, it's its own thing, like you and I are our own things. It's separate and distinct from us. In the eyes of the IRS, it may or may not be separate and distinct from us. So when a trust is what's called revocable, it means you set it up, you can revoke it or terminate it or change it at any time. That's a revocable trust. You can put stuff in, you can take that stuff out. You, because you the grantor, you're the one who's putting stuff in the trust and the one who created the trust, you control it as if it's functionally you. It's one and the same as you almost. Therefore, it's taxed as you. So from a tax perspective, all the income and assets and whatever aren't taxed as if they're in the trust. They're taxed as if you still have them. So what's the legal significance of it being in trust? Well, for estate planning purposes, if and when you die, the stuff in the trust now does not have to get pulled back into probate. It stays in the trust. Again, the trust is legally its own thing. You died, the trust didn't. The trust lives on potentially indefinitely if you wanted to. Again, it's its own legal thing. So the trust owns the assets now, not you. Therefore, it's not part of your estate. It doesn't... if it was revocable, it gets pulled back into your estate for tax purposes. Let me step back then and say what irrevocable trust is. So irrevocable trust is unlike revocable, where you can put stuff in, take stuff out, you can change the terms, you can cancel a trust anytime. Irrevocable means once you set it up and once you put stuff in it, you gave it away. It's not yours anymore. You can't decide, you can't go in and change the trust. You can't say, oops, I made a mistake, I want it back. Done. It's gone. Now you can control what the trust is able to do with the stuff, meaning when you set the trust up, you're the one who can draft and create what the purpose of the trust is, what you want the trust to do, where you want the assets to go, whatever. You can control that beforehand, but once it's in there, boom, it's not yours. Therefore, for a tax perspective, the stuff in the irrevocable trust is no longer taxed as if it's yours. It's not taxed on your own tax return. The trust now has to do its own tax return. In the eyes of the law, it's its own thing, and now in the eyes of the IRS, it's its own thing. Here's where trust taxation gets ugly. Unlike people whose tax rates range from 10 to 37%, for a single person, for example, you only pay 37% on income above $520,000. Every income up to that is tiered, between 10 and 37%. With trust, the tax brackets for trust are super, super compressed. The 37% tax bracket starts at like $13,000 of income for a trust. $13,000. So the second a trust has more than $13,000 of income, and every dollar beyond that is going to be taxed at 37% in the trust. That's why trusts by themselves are not inherently tax efficient things. So long as money stays in that trust, it accumulates and is earned by the trust, it's heavily, heavily taxed. Where was I going with that? Oh, so that gets to the question of, and a few people ask this, I'm sorry, just looking at a question here. Right, okay. Cody asked, can I touch on which types of accounts receive a step up in basis versus IRD? Hold that thought. Yes, great point, Cody. Trust, right. So the question was, and the question in the group a few times was, if I have an IRA and there's a beneficiary form, as we all know, and I have a trust, could I or should I name the trust as the beneficiary of the IRA because it stays out of probate and the trust has its own rules that says what to do with the money and whatever? And a lot of lawyers will say, yes, go ahead and run everything through your trust. Now, I think that's partly because they don't understand the tax implications. And yes, it is on the surface simpler and easier to just have one thing that all your stuff runs through, and instead of having some passed by insurance, some passed by a beneficiary form, some passed through a will, lawyers are like, just run it all through the trust. Well, the potential downside is if you leave an IRA to a trust, an IRA is not an asset. You and I view it as an asset. You look on your balance sheet, your net worth, you see it as an asset. but it's not. An IRA is one big pot of income, specifically income that has not yet been taxed. So after you die, all that income needs to come out and needs to get taxed by whoever owns it. If you leave your IRA to a trust, guess what? The trust now is the owner of that beneficiary IRA. The trust is the one who has to distribute its income, and the trust is the one who has to pay its trust tax rates on that income. And again, trust tax rates, every dollar over $13,000 is taxed at 37%. So that's horribly tax inefficient to leave tax deferred monies, IRA, 401k, 403b, whatever, to an IRA, to a trust. Now, there are some exceptions. There are trusts called conduit or see-through trusts, which avoid this thing, and the trust exists just to be this, literally a conduit. The assets go in, they come back out to whoever the ultimate beneficiaries are. And the income is therefore taxed in the hands of the ultimate beneficiaries. Nothing is taxed at the trust level, it just flows through. Can that work? Yes. Is it potentially dangerous? Yes. Because what if your trust wasn't properly set up as a conduit or a see-through, and your IRA now gets stuck in the trust and the trust has to pay tax on it? Just don't do it, especially since it's so simple and easy to transfer an IRA as it is, because you have this beneficiary form in your IRA or 401k or pension or whatever. Just do that and leave it at that. You can run it through a trust, it can work, but it's just asking for more trouble than I'm comfortable saying you should take on in most cases. Again, there are exceptions. If protection and control is more important to you, meaning your heirs are spendthrifts, drug problems, mentally unstable, special needs, then yes, maybe you want or need that money to stay in the trust and owned by the trust and parsed out over time by the trust, and you're willing to deal with whatever tax implications that has because the protection and control is more important to you than the tax. That's something to consider. But in most cases outside of those, I would not recommend naming a trust as a beneficiary of any sort of tax deferred account. Just stop at the beneficiary form. Name it there, done. Leave it as it is. All right, so that's revocable versus irrevocable. Again, revocable, still sort of yours while you're alive, taxed as you, functionally looks and acts like you can put stuff in, take stuff out. Irrevocable, different story. Once you give it up, boom, those assets are gone, they're out of your name. Not taxed as you anymore. The trust now pays tax on whatever's in there. When you have a revocable trust and you die, that becomes usually, if not always, becomes irrevocable upon your death because you're no longer alive to try to revoke it. Then the trust does what it's going to do as stipulated in the trust agreement as to what happens once you die. With that said, there's also other ways to slice and dice trust. There's living trust and testamentary trust. Living trust are trusts you set up while you're alive. That would be like a revocable trust. A testamentary trust is a trust that doesn't come into existence until after you die. So you can put in your will, you don't have a trust now, but your will says upon my death, create this trust, all my stuff goes into the trust will then hold all this stuff for 20 years and then pay it out every year thereafter. That would be a testamentary trust because it's created, I'm not quite sure what exactly the root of testamentary is, but that just means the trust was created after your death, basically through your will, created by your will. Just one other piece of lingo. There's basically three parties to a trust. There's a grantor or creator. That's like you when you make the trust and you put stuff into it, you're the grantor. All trusts have a trustee. A trustee is the person or entity that oversees and administers the trust and has to act as a fiduciary, meaning has to do what the trust wants it and instructs it to do and always act in the trust's best interest. That could be you. If it's a revocable trust, you can be the trustee, again, because revocable, basically it still looks and acts like yours. Irrevocable, you cannot be the trustee. At least I don't think you can. You usually need, if not always need, an independent person, whether it's a relative or a professional trustee, like a trust company, to be the one who oversees the trustee. And then there's beneficiaries. Those are the people who eventually get stuff out of the trust, based on the trust document, the trust agreement. It'll say what goes where and when, and that stuff goes to the beneficiaries. That's the skinny on trust. I'll leave it at that because there's lots of different kinds of trusts for lots of different reasons again. But those are the common ones: revocable, irrevocable. living versus testamentary. There are tax differences to be aware of, etc. All right, so Cody asks, can you touch on which accounts receive a step up in basis versus IRD? I'll explain what that means. So step up in basis means for non-retirement accounts, so non-tax deferred accounts like your house, like your regular brokerage account, things like that. If you die, the value of that stuff on your death is the value at which the people, your beneficiaries, get it from you. Your date of death value will be their assumed purchase price, if you will. And let me give an example. And I had a comment about this in the group a handful of days ago. You bought shares of Microsoft a long time ago for $100. They're now worth $100,000. That's 999, whatever. It's a lot of gain that's been built up in there that if you sell while you're alive, you need to pay tax on all that $999,000 of gain. If and when you die, whoever you leave those assets to, that person will inherit those assets as if they bought them at $100,000. So all that $990,000+ of gains you had magically goes away for tax purposes. The person you inherit it from starts fresh as if they bought it at $100,000. So the only gains above and beyond $100,000 while they own it will be taxable to them. That's step up in basis. Tremendously powerful estate planning tool to leave assets and skirt a lot of taxes in the process legally by doing so. IRD stands for income in respect of decedent. So tax deferred retirement accounts, IRAs, 401ks, 403bs, etc. They do not get step up in basis because again, those aren't assets. Those are pots of income which have not yet been taxed. They're called IRD, income in respect of decedent. Decedent means the person who died. So you inherit an IRA, doesn't matter what price the decedent paid for the stuff or how much they contributed versus how much was growth, doesn't matter. Whatever that account value was on that person's death, all of that is income you need to take out. And now under the Secure Act, you need to take it out for most people within the course of 10 years, but it's all income that will be fully taxable to you at whatever your tax rate is. That's IRD, income in respect to decedent. Now that's if it's tax deferred. Roth accounts are still considered IRD in that they're income you need to take out, but they're not taxable. In most cases, you inherit a Roth IRA, you still need to take it out within 10 years, but there's no tax on it. You just simply take it whenever you want to take it, and it's free money without taxes for you. Good question, Cody. Joy asked, do spouses each have their own trust? They could. It's not necessary. I've definitely seen single spousal trusts. I guess it depends what your intentions are and how separate you want to keep stuff and what your state laws allow, Joy. I definitely, yeah, sure they can be. I don't know of and can't think of reasons why you would or wouldn't want to, but yeah, I don't know why you can't have your own separate trusts as spouses. All right, 9:12. There's 3 more questions here, and then we'll wrap it for those of you that are still hanging around. Shook asks, what can you do then for tax strategy for estate planning not in a trust? Oh boy, that's a good one. Whole lots of things, and that's kind of like the whole purpose, or one of the main purposes of this taxes and retirement group. So right off the bat, step up in basis is one thing we just discussed. If you have highly appreciated securities that you don't plan on ever needing to sell and use, it will be good to leave those to your heirs because they'll all get stepped up and the taxes basically go away. So that's a tax efficient way for you to basically get rid of a tax you'd otherwise have to pay by giving these assets to someone else. That's one. If you're charitably inclined, leaving your tax deferred assets to a charity are better than leaving your Roth assets, because $100 of IRA in the hands of your child or whatever, they need to pay tax on that $100. $100 in a Roth IRA, your children do not have to pay tax. So all is equal, your children would rather get the $100 in your Roth. If you want to give to charity, leave them the regular IRA because charities don't pay tax. So that $100 that would otherwise be taxable in anyone else's hands is now all tax-free money in the hands of a charity. So that's one way. Just simply minimizing taxes while you're alive, like doing things like Roth conversions and spending down your tax deferred money while you're in low taxable income years. Just saving the tax bite or minimizing your tax bite indirectly minimizes the tax bite for your eventual heirs. To the extent you do need to worry about estate taxes. Most people aren't going to exceed the $11.6 million estate tax threshold, but assume that will come down at some point. If that comes down a lot, then you may need to start worrying about it again. If it drops back to $2 or $3 million of estate tax limit, a lot of people are going to have to worry about planning for estate taxes. Then trusts start to make more sense. That's another potential tax thing. Shook, good question. Ken asked, if I put my condo into an irrevocable or revocable trust, when selling it, the seller would be the trust, not myself. Yes, and this is where irrevocable trust can get messy, because the trust, so if you give your condo to an irrevocable trust, that condo is no longer yours, the trust owns it. The trustee now has to decide, can and should the trust sell it. You have no say. Now practically, maybe the trustee is your brother and he's just going to do whatever you tell him to within the confines of what the trust agreement says, but legally you have zero control over that asset. The trustee now would have to sell it on behalf of the trust. If it's revocable, yes, the trust still owns it, but guess what? You're probably acting as the trustee if you set up a revocable trust, so it's not going to be that big a deal for you to step in, as a trustee and say, yes, I'm fine to sell this condo. Wendy, while it would be more heavily taxed, is there any benefit to putting assets in a trust while your children are minors? I guess it depends on the circumstances. Again, protection and control. If for some reason you want to lock that money up so other people can't get at it, or you want to otherwise control it, what happens, where it goes, where it doesn't go, then yes. But outside of wanting to protect or control that money, I'm not sure. No benefits are coming to mind, Wendy, as to why you would do that while you're alive, other than if it's just like sort of foresight and trying to get ahead of your estate planning and you want to run everything through a trust just for simplicity's sake upon your passing, then maybe, yeah, you start putting stuff in a trust, but may not be necessary. If one of your children has special needs or there's other extenuating circumstances, then yes, maybe trusts matter more, again, to protect and control and shield those assets from from the state or the government potentially taking them to pay for services, necessary services or something. And what else? So Cody just chiming in about step up in basis. So yeah, that's another interesting point, Cody. Thank you for bringing that up. So normally when you buy and sell something, if you own it at least a year, it's called a long-term capital gain, and it's taxed at a lower rate than a short-term capital gain, which is inside of 12 months. Short-term capital gains are taxed at your regular income tax rates. When you inherit property that's been stepped up in basis upon your inheriting it, you don't need to wait a year to sell it. I need to double check that, but I think as soon as you sell it, it's whether you sell it the day after or 13 months after, it's considered a long-term capital gain. Now, the only thing I'm not sure of, and Cody, maybe is if, let's say the person who originally owned it, the decedent, only owned it for 2 months. They die 2 months later, you inherit it. Do you need to wait 10 months to round out a full 12 months, or does it not matter how long the person held it, how short it was? It's always long-term capital gain. That I don't know, but that would be an interesting thing to look up. All right, looks like that's it for the questions, and we are about 20 minutes over time. Thank you all for joining. Hopefully you enjoyed this. I will see you back next week. I don't remember what next week's topic is, but I'm sure it's going to be awesome. And I just posted the new schedule. Oh, one other reminder for those of you that care, the TERP poll. So again, I'm priding myself on having come up with the term TERP, T-E-R-P, tax efficient retirement planning. I put out a feeler to you all to come up with names for people who practice TERP, like Terpian or Terper or Terpostle or Terpinator. There's a lot of really good suggestions so far. For anyone who hasn't voted and wants to, or hasn't come up with a name and wants to, go back to that post from a few days ago. You'll find it in the feed. This Friday, I will be stopping taking suggestions, and I'll be putting a poll out to the group. I'll pick the top handful of names and let you all poll which name you like. Whatever one wins, that will be deemed the official name for a person who is a practitioner or student or follower of TERP. Super exciting stuff, I know. 1 second. All right, good. Yes, so I just got a text from someone else who said upon step up in basis, it is all long-term capital gain. Does not matter how long or how short the decedent held it. Good to know, so thank you for that. All right, that's it. I will see you next week. Take care.